Morning, everybody. Welcome to the First District Court of Appeals. Okay, good. We've got video now for Mr. Thuman. Can both of you introduce yourselves and you're ready to indicate your readiness to proceed?
Sure. This is Rob Thuman. I represent the appellant, Cross Appeal American Trading.
Okay.
We're ready to proceed. I'm ready to proceed.
I'm Michael Conway. I represent Irene Donopoulos, and I'm ready to proceed.
Excellent. Mr. Thuman, how much time would you like for rebuttal?
Maybe 5 minutes, please.
Okay. And Mr. Conway, since you are also the cross appellant, you can take rebuttal if you would like. Would you like to take rebuttal time?
Maybe 2 minutes, Your Honor. Thank you.
Sure. Okay. Thank you both. Mr. Thuman, whenever you're ready.
Thank you, Your Honor. May it please the court. This is a very interesting case procedurally, but a very simple case that's actually before the court today. This is the third appeal on this matter before the court. And in fact, it was even sent to the Supreme Court on one matter, but was improvidently accepted and sent back down. It was a case that we were initially successful on summary judgment. That was reversed by this court, went back down to the trial court, had a bench trial. That was appealed, went to the first district again, was reversed. After that reversal, the Supreme Court did accept it, but again was found that it was improvidently accepted and sent it back for decision just on damages. Again, interestingly, the summary judgment was Judge Myers. That's now, of course, your colleague. The trial was held in front of Judge Hartman, who is no longer a judge. And then after it went to the Supreme Court and came back, ultimately it was decided by Judge Baradon. So there's been kind of an interesting procedural posture, but really all that is before this court today is the measure of damages. When the case came back down before Judge Baradon, the issues of liability had been resolved, and the only remaining issue was damages.
Right. And so if the question is simply damages and you presented one measure of damages and the plaintiff presented another measure of damages, on a manifest weight, the judge went with the other side's damage calculations. Why, what's wrong with that?
Correct. There's two issues presented before the court. The first is essentially whether or not the opinion of the plaintiff's expert should have even been admitted at all in the case. There was a motion made during the trial to have that opinion excluded. It certainly did not meet the standards of Rule 702, and it certainly did not meet the Daubert standards and should have been excluded by the court. Judge Hartman even acknowledged in the trial transcript that there was much speculation in the opinion, but keeping in mind this was a bench trial. Now, if this was a jury trial, it's hard to say how it would have happened, but I think we all know that in bench trials, judges are certainly more willing to allow evidence in than it would be in a jury trial.
But I think that the issue you're talking about in terms of speculation is it's not unique to that expert. It's what any expert facing the situation where the jewels have been sold to someone else and the pieces have been destroyed. No one would be able to look at that because those pieces don't exist and say, I can give you 100% certainty on the calculation.
Well,
it's your client's fault that they were destroyed.
That's not exactly true. That's not exactly true. My client was a lawful possessor. If I could address the second thing that you said first, and then I'll go back.
No, and I'm not meaning from they bear responsibility because they acted inappropriately. I'm just saying your client is the one that did destroy those and sold them off to someone, which means we don't have the actual pieces to examine by an expert witness.
Well, again, that gets to part of the argument that the appellee made in this case, where we were the wrongful actor in the case, and therefore that should be construed against us. But that's not the case. We were not a wrongful actor. We were lawfully in possession of the jewelry, We acted appropriately. We acted within the law. Again, if we would have intentionally destroyed jewelry when we knew that it was stolen, or we knew that the original owner was coming back to get it, and we destroyed it and passed it on, that would be one thing. But that's not at all what happened here. What happened is
Mr. Freeman, if I could just inject some, I guess I'll call it good old West Side logic here. To expand on what Judge Bergeron is asking, no one's accusing your client of doing anything inappropriate. However, the actions of your client rendered perhaps a more exact appraisal of the property. Can you cite me to anything, any kind of case law that would support your version that it should just go back to whatever he got for the property? Is there anything?
Well, I cited that in my brief. There's decisions. The initial decision that I cited was Perez Bar and Grill versus Schneider. That's 2012 Ohio 5820, and that stands for the premise that the true market value is based on what a willing buyer and a willing seller would do in an arm's length transaction. There's another case that I cited in my appeal, in my brief, which is State X Rail Park Invest versus Board of Tax Appeals. That's 175 Ohio State 410, and also Zukowski versus Franklin County Board of Revision, which is 70 Ohio State 3rd. These are all in my brief. And it stands, and this is where I was going to go after I tried to defend my client's action, which I realized maybe wasn't the question that was really posed to me. So I'll address that question now. But if that's all that they had, I understand that. And that goes to my second issue for review, which is even if the court did allow the opinion to come in, and then there's a weighing of the evidence as suggested, the more appropriate measure would be what a willing buyer and a willing seller would buy and sell the jewelry for in an arm's length transaction. And we have that.
Mr. Thuman, the seller is presumably a thief, and it seems to me a thief would take anything they could get. So they wouldn't really be, it really wouldn't be an arm's length transaction, would it?
Judge Winkler, I was moving directly into that point in that regard. So there was two transactions that took place. The first was in fact the transaction where the thief sold to my client. That purchase price was $2,125. I can understand an argument that a thief would take anything, and therefore maybe that is not a true arm's length transaction. But there was a second transaction that also took place, and that's when my client that had no information, no knowledge, and there's absolutely no evidence that he had knowledge that jewelry was stolen at the time. And again, as I said, was a lawful possessor at the time. Then after the waiting period, he then sold the jewelry to another merchant. And that transaction was $7,064.30. It's uncontested that was an arm's length transaction. That was my client, a merchant, and another merchant that had an arm's length transaction. So certainly that would be the best evidence of the fair market value based on the law I cited. And then certainly if you read the transcript of Michael Karaman's testimony, where he says, he doesn't say with any certainty whatsoever the value. He says he uses words like it should be, it could be, but
I mean, he's in a bind because he doesn't have the piece to actually inspect.
I don't deny that.
He's trying to come up with like a midpoint valuation, which I think is, somewhat conservative under the circumstances, and frankly doesn't give any valuation for the actual pieces that were destroyed. So in other words, like the artistry and the history of the pieces that he was talking about, like I think that's essentially valued at zero, as I understand his testimony.
Just because he did the best he could doesn't make it admissible expert testimony.
Okay, so then that prompts the question that I started with, which is, could any expert, under your view of the case, have opined at all on this under the circumstances?
It's possible, because again, if you go back and read the transcript of his testimony, he did no research. He consulted no other experts. He only looked at a black and white photograph that was given to him by plaintiff's counsel the day before his deposition. He never spoke with with the plaintiff or her husband. The only information that he got was provided to him by plaintiff's counsel. He did absolutely no research other than looking.
But I guess my question is, like, this person, this is his whole business. He buys and sells jewels all the time. I mean, doesn't he have a baseline of knowledge of valuation without needing to do independent research?
No, absolutely. First of all, the first part of your comments or questions, I agree with. At no point have I attacked the credibility of this witness. From the trial transcript, after my argument on the motion to have his testimony excluded, Judge Hartman asked me that very question, and I made it clear. At no point did I dispute his qualifications or credibility, but the manner that his methodology in coming to his opinion was absolutely flawed. He made no effort. He did no research. There's certainly no peer review for what he did. Absolutely, his testimony could not at all conform with either a Daubert test or Rule 702.
Wouldn't a better way to make that argument, however, been to bring an expert of your own who used perhaps different methodology?
It's possible, and we did consider that, but again, the best evidence is the actual funds paid for an arm's length transaction. Because if I would have brought an expert in, he or she would have had the same obstacles that plaintiff's expert had in this case. So again, certainly the best evidence was the evidence of the transaction, and just not necessarily to get into trial tactics. But
well, Mr. Thuman, you are at your time. I gave you a little bit extra because we peppered you with questions. But if you'd like to reserve 5 minutes, we'll turn it over to Mr. Conway at this point.
Thank you, Your Honor.
Okay. Mr. Conway.
Thank you, Your Honor, and may it please the court. In this case, we fought an uphill battle all the way. One of the big reasons is because we don't have the jewelry. Had we had it, it would be very easy to submit it to an expert who would value it. The one big problem we have is that the pawn shop is required to photograph the jewelry and send that photograph to appropriate law enforcement. The photograph that the pawn shop took appears to be a photocopy from a copying machine. It's not very clear. It's black and white. And in contrast to what Mr. Thuman said earlier, the expert did have color photographs of the items of jewelry which Mrs. Tonopoulos was wearing in each of those photographs. So he had photographs of all three pieces of jewelry from her. The problem was he could not identify the bracelet from the black and white, apparently photocopied picture of that bracelet from the pawn shop. So he couldn't say, gosh, that's the same piece, and here's what the value is. However,
yeah, and I was confused by his testimony because he didn't offer any valuation of the bracelet, did he?
Well, not of the bracelet itself, because as soon as he said, I can't even identify, I don't know what that is. The fact that Mrs. Tonopoulos had a photo of her bracelet seemed to me to be irrelevant because we couldn't tie it to the case. Excuse me, I have allergies that were acting up today. I think the issue there is that with the two pieces of jewelry, the ring and the brooch, that we could identify in the photo or photocopy from the pawn shop, Mr. Karaman obviously could see what they were. He had descriptions to which Mrs. Tonopoulos testified in the case as to the size and the number of diamonds and all those things. So I don't see the problem with him valuing those. He did the best he could. With regard to that bracelet, Mrs. Tonopoulos testified that it was 10 carats of diamonds. Mr. Karaman testified that the going rate for an average diamond in Cincinnati at the time was $1,500 per carat. Seems to me that's $15,000. And the fact that the bracelet was proven to have been converted leads to a valuation of some kind.
But why didn't you ask him the question of, based on her testimony, she says there's 10 diamonds in it. Here's her description of it. Even though you don't have the bracelet in front of you or a reliable photograph, if you assume that that is accurate, what is your opinion as to the valuation? Why wasn't that question answered?
Well, Your Honor, at the time, Mrs. Denopoulos had not yet testified. We took Mr. Karaman's deposition for preservation and use at trial. So that was a while before the trial itself. Mrs. Denopoulos had not yet testified as to the number of carats in the bracelet. And frankly, I didn't know what they were. I didn't know what it was. I think for that reason, the whole thing would just, there was no way he could testify to the value of it, of the bracelet. So my point is that he did testify that $1,500 per carat. She testified as to 10 carats. Seems to me that's a simple mathematical calculation. It's not speculation at all. So when I look at it, there are the cases I cited. I didn't find anything in Ohio, but the Story case, Story Parchment case of the Supreme Court, which I cited and which Mr. Thuman said, says the damages may not be determined by mere speculation or guess. But the quote on page 2 in his brief goes on to say, but it would be enough if the evidence showed the extent of the damages as a matter of just and reasonable inference, although the result may be only approximate. That's what we have here, seems to me. So I would ask the court then to value the bracelet at $15,000 and add it to what the trial court has already determined. And that's a total of $54,500.
Mr. Conway, this is kind of a side issue that's just barely mentioned in the briefs, but would you comment on the insurance set-off?
Your Honor, there were several items taken in this robbery. One of them was an Apple computer belonging to Mrs. Denopoulos' daughter. There was, it seems to me, I think it was a cell phone, and there were 8 other pieces of jewelry. Now, Mrs. Denopoulos found the 8 other pieces of jewelry at a pawn shop in Montgomery County through the work of Detective Ridgway. She went to the pawn shop and actually paid to get those back. So she paid the pawn shop the amount that the pawn shop paid for those items. Unfortunately, in this case, the defendant had already sold or melted the pieces of jewelry, so she couldn't buy those back. She was happy to pay those too. And Detective Ridgway told the person at the pawn shop that she would have paid for that. So she got $1,500, I believe, from the insurance. She paid more than that to get her other pieces back. And she never, as far as I know, I don't know that she recovered that computer. So our point was that she's already lost more than that with the other items. And so that none of that really paid for any of this jewelry. So that's all I have today.
Okay. Thank you, Mr. Conway.
Thank you. Thank you.
Mr. Thuman. You're on mute.
Oh, got it. Initially, I believe that I answered Judge Hendon's question about why we didn't hire our own expert, but if Judge Hendon, if you'd like me to expand on that a little further, I can. But if not, that's.
Well, I'm curious about that, yes.
Yeah, again, it's the same. Again, we would have had the same obstacles. Again, I'm not critical of plaintiff's expert for the position that he was in. I'm not. I understand that. But again, just because he had a tough go at it doesn't make his testimony admissible. Again, if you go through his testimony, it's just all pure speculation.
But let me ask you this. So let's say she testifies that, let's take the bracelet, that there was 10 diamonds and there were 10 carats. And I know that because I asked when I bought the bracelet. And then he comes on not seeing the bracelet because he can't, and just says the going rate for a diamond, a 1 carat diamond in this market is $1,500 or something. I guess, does that solve your speculation point if the opinion is just limited to that?
Absolutely not. He admitted that he didn't know the color, the clarity, the size, the cut. He speculated to the age, and so forth. It's just, you know,
Isn't that why he used an average value per
I'm
carat?
sorry, Your Honor. I didn't.
Isn't- Because of the very things you're saying, he didn't know the color, the clarity, the cut. He used kind of an average range. I mean, he wasn't using the highest grade diamond cut in his appraisal.
Again, but that does not make it admissible expert testimony. Just because he had a hard road to go, he can't just guess. He can't just, there's no law out there that says just because you can't do a proper evaluation, you can just give a middle of the road testimony in that opinion, and that makes it admissible. It just doesn't. It's just, again, just because it was difficult, you can't say, okay, he had a difficult job, so it's admissible. It's still got to meet the standards of Rule 702 and Daubert, and he didn't do that. So we got to go with the best evidence that we have, and the best evidence that we have is what was sold and paid for the jewelry, and that kind of takes me to
What about, well, if that's the case, what about one of the pieces? Didn't Ms. Xenopoulos testify that she paid a specific amount for it?
Well, I mean, again, that does not necessarily create the value. There was no, I don't know when she said she paid for it.
Well, but I like you're saying it, what is critical is what a willing buyer and a willing seller pay. Then if that's the case, isn't the fact that she bought it for a specific amount highly probative of the valuation?
She did say that about the brooch, that she paid $8,000 for it. Certainly she didn't say anything about the ring. You know, the ring was there was no testimony about the value of the ring, but she did say that she paid $8,000. But keep in mind, the way that the expert got that information was not by talking to the plaintiff. That information was provided to the expert only by counsel. Again, this expert did nothing, no research. He looked the day before his testimony, he looked at some photographs. Again, did no research, there was no peer review, just absolutely no effort to even do as good a job as he could. And again, I keep saying it, just because he had a hard job doesn't make it admissible. We have to go to the best evidence. And I want to make just a very quick side point, because it's something that came up in Mr. Conway's argument, is that there was other jewelry sold to other pawn shops. And if you go back to the trial transcript, you'll see a little bit of questioning that I did with the Montgomery County detective about the value of that jewelry that was bought and sold at those pawn shops around Montgomery County. And it was just a couple $1,000s for very similar jewelry. So again, we have another scenario where we have similar jewelry with actual transactions. And again, the amounts are nowhere near $31,000, nowhere near $8,000. They're valued in the range where my client sold the jewelry. So, you know, that again is better evidence than we have as some speculation from an expert versus actual evidence of a transaction that took place. So one other comment that was made about the value, that when he said the value of diamonds, he didn't use the proper time frame either. And if you go to the transcript of his testimony, he valued the jewelry at a 2016 value versus where it should have been valued at 2014. And he made no effort to go back and determine what the value would have been in 2014, which would have been the true measure. So again, another flaw in Mr. Carraway's testimony, just to show again that he just didn't do the work. He didn't put the work in that would have been necessary, the research in that would have been necessary to give the best opinion that he could.
And Mr. Thuman, you are at your time now.
Thank you, Your Honor.
Thank you. Mr. Conway.
Well, Your Honors, only one comment, and that is with regard to the other jewelry, there is testimony that the reason the other jewelry was sold in Montgomery County and this jewelry was not sold in Montgomery County is because the pawn shop owner in Montgomery County said, gee, that's really unusual jewelry. It's not something we deal in, much more valuable, much harder to sell. I'm not interested in buying that jewelry because I don't know I don't know anything about it. It was much more exotic and so on. It was entirely different than the jewelry that the Montgomery County pawn shop bought. So it wasn't comparable at all. And there's no testimony as to the value of it. The only testimony is, even if, I don't recall there was even any testimony as to the value of it. So the long and the short of that is, I don't think it's comparable. And certainly that would be speculative to base anything based on the value of those other pieces.
Great. Thank you, Mr. Conway. Thank you both for your arguments today. The case will be submitted and we'll get out a timely written decision.
Thank you very much.
Thank you.
Have a good day.
You too.
Good morning. I kind of inadvertently logged myself out, so I'm now logged back in.
No worries, we got you back. Good morning, everybody. Welcome to the First District Court of Appeals. The last case on the docket today is State versus Martin. Ms. Nelson, would you like to reserve any rebuttal time?
Yes, please. Can I reserve 3 minutes?
Yes, you may.
Thank you.
All right, and you may proceed whenever you're ready.
Good morning. May it please the court, and good morning, opposing counsel. Sarah Nelson here on behalf of the appellant, Abby Martin. This case this morning is in regards to the application of the good faith exception to the exclusionary rule. And of course, there are exceptions to the exception, and there are 4 exceptions, in fact, to the good faith doctrine when good faith would not apply. And the one relevant to this appeal is whether police relied on a warrant based on an affidavit so lacking indicia of probable cause that no officer could reasonably believe in the existence of probable cause. So we apply an objective test to answer this question and decide whether a reasonably well-trained officer would have known the affidavit in this case was lacking indicia of probable cause so that there could be no reasonable belief upon the existence of probable cause. Now, the trial court in this case found that the trash pool evidence and the Butler County investigation information supplied in the affidavit combined fell well below the standard of probable cause. But where the trial court erred is in finding that despite lacking probable cause, that the officers nevertheless were acting under good faith. Detective Mayer, a 10-year veteran of the police force, So therefore, a reasonably well-trained officer should have known that the affidavit in this case was so lacking in indicia of probable cause, it was unreasonable for him to believe that probable cause existed. And so therefore, under these facts, we're asking this court to reverse based on the trial court's error in finding the good faith doctrine applicable here in order that the motion to suppress be granted. Now, there are 3 cases cited in my brief that I think are helpful to answering the good faith question in this case. State v. Hampton from this court, State v. Gales from the 8th District, and State v. Jones from the Ohio Supreme Court. State v. Hampton is instructive because it concerns an affidavit lacking in probable cause, but the application of the good faith exception. And in that case, the officers were given a little bit of leeway because the information that they had relied on wasn't clearly delineated in the case law in terms of its relevance to supporting probable cause. So in that case, the officers had used their limited knowledge of a particular substance that they thought was only used for, or they thought was primarily used for cocaine filler. But this court said, well, it has other uses, and in the future, the existence of this finding alone would not be used to support probable cause, and we're not going to apply the good faith exception. So what the good takeaway from this case is, what law is in effect at the time of the affidavit being submitted that we need to hold the officer accountable to. In this case, those
And
two.
so what you're focused on are the cases related to trash pools and whether those suffice to establish probable cause. Is that right?
Yes, in addition to this staleness concept. So here, a single trash pool, it's well known that a single trash pool standing alone cannot establish probable cause without other information supporting, that the target residents would have what the trash pool is sort of consistent with. In addition to staleness, it's well known that stale information standing alone can't support a finding of probable cause.
So let me ask you this about the affidavit. I mean, the information obviously was from Butler County. If this had been the residents in Butler County rather than this new residence, and there had been this, even though it's stale, information that out of this house they were running some sort of drug operation, and then you had that plus the trash pool, would that have been enough?
If we were talking about everything happening in Butler County?
Correct.
Well, I think under Gales, it would still be stale and not enough. And in Gales, there was a 7-month lag between a CI purchase with the defendant, and then before the search warrant was applied for, a 3-month hand-to-hand sale, right? So I think to answer your question directly, even if this wasn't Butler County, that information still would be stale. And I'm looking to Gales for that position because of the fleeting nature of, the perishable nature of drugs, right? So that's kind of what we're dealing with here. And you got to have more timely information with respect to this type of conduct to suggest that it would be found inside the target residence.
Ms.
So-
Nelson,
Let me.
go ahead.
Go ahead, Judge Handon.
Well, I think I know the answer to this question, but I just want to make absolutely sure. The brief seems to indicate that this exact same information had been used in a prior criminal action. Is that correct up in Butler County?
Yes, Your Honor, that's correct.
And I think in your brief, you also indicate that it was essentially copied and pasted, like 27 paragraphs were copied and pasted. Is that correct?
Yes, that was the detective's testimony that it was copy and pasted, repurposed.
Is there anything on the record that you can point to that would indicate the conversation that was clearly not included in the warrant? There's some mention that the officer in some way clarified all that to the issuing magistrate, whoever that was?
I believe that the officer did testify to that. The particular transcript citation, I don't have off the top of my head, but I do think that the detective in this case alluded to the fact that he had this conversation with the issuing judge. But even with that in mind, it doesn't overcome the.
But there weren't any, as I recall, there weren't any details of that conversation other than the fact that he had the conversation. Is that?
Yes, that is correct. Yeah, it's a very cursory, like this conversation was had, we don't know substantively what I guess the issuing judge knew other than this information came from Butler County.
Ms. Nelson, let me ask you a question. Your argument is that there was not good faith and therefore, that the officer was not acting in good faith. But doesn't that presuppose that we are charging the officer with knowledge and legal interpretation of the trash pull cases and asking the officer to make a legal determination about what is and what is not sufficient in a trash pull? And isn't that why we have the independent magistrate to make that decision? And I guess that's a kind of a long-winded question. Leading maybe to the real question is, how does that show that the officer acted in bad faith?
Well, so the objective test that accompanies the good faith exception question, asks whether a reasonably well-trained officer should have known that the affidavit was lacking in probable cause. So it does, in fact, require some reasonable level of knowledge as to what supports probable cause. So to answer your question, I mean, yes, it does to an extent. We're talking about reasonableness, not, expertise, right? So we have to, in this case, we're dealing with two specific concepts: a single trash pull and staleness. And those are not overly complicated legal concepts for a 10-year veteran of the police force to know and understand their force in terms of applying for a search warrant. So yes, there is an expectation that an officer, a reasonably well-trained officer, should know what is expected with respect to establishing probable cause. And that is one thing.
Sorry, let me ask you this follow-up. I mean, here an independent magistrate wrongly perhaps concluded that there was enough information for probable cause, even though some was stale, even though it was a single trash pull. But I hear you saying that an officer not trained in the law should have, in good faith, come to a different conclusion. And to me, I'm hung up a little on that, because bad faith would be false information or information that really was so tenuous that the officer herself didn't have a good faith basis to believe. But here, the facts were true, and the court made a determination that I shouldn't say the court, the issuing court made a determination there was probable cause. And that's why I'm having a little trouble finding that there's bad faith by the officer.
I agree with you that the concept is a little wonky. And I would encourage this court to look to State v. Gales for reassurance that there could be a warrant issued and an officer be found to not have acted in good faith, because that's exactly what happened in Gales. They had a drug investigation that did not involve the target residence, but it did involve the defendant. And under, reviewing the affidavit, the court found that based on the four corners of the affidavit, there was not enough here for a reasonably well-trained officer to have reasonably believed in the existence of probable cause. So despite the issuing magistrate, or despite the fact that a warrant was issued, there is still an exception embedded within good faith, an exception to good faith that allows for this type of decision-making. And it does cut against sorry, go ahead.
Wouldn't that mean, though, that in any case where ultimately it was determined there wasn't probable cause, under your argument, the officer would be acting in bad faith?
The language, it doesn't come out and say bad faith when this type of finding is made. It just says that an officer was unreasonable in believing that probable cause existed. So it's not our traditional concept of bad faith. It's just what does a reasonably well-trained officer know and do under these circumstances. So,
but if I follow your argument to its logical conclusion, anytime it was found by a court that there was not probable cause, under your argument, that would mean a reasonable officer should have known that at the time, and therefore could not have acted in good faith, or could not have acted reasonably.
No, Your Honor, and that I would encourage this court to contrast the findings in Gales with the findings in Hampton. So in Hampton, there is some leeway when there is a finding that probable cause did not exist. But like when we're talking about first-time instances, so in Hampton, in this court's decision in Hampton, they gave the police leeway despite finding no probable cause in the affidavit, because the drugs at issue, the police weren't exactly aware that the drugs had other pharmaceutical uses. So they said, hey, police, next time, you will,
So
won't be
you're
permitted-
drawing a distinction between areas where it may not be settled and the court finds no probable cause versus issues where it is settled and the court finds no probable cause and the officer should have known that. Is that a fair encapsulation of what you're saying?
Absolutely, absolutely. And I would go one step further and to say if the, like, so in this case, I'm talking about settled legal principles surrounding staleness and trash pulls. If there was a nuance where, you know, one of those two concepts is being addressed for the first time, then maybe even in that situation, good faith might apply, but that's not what we have here. We have very concrete concepts that the officer just ran afoul of. And the good faith exception that I'm relying on this case does allow for reversal and exclusion.
Thank you, Ms. Nelson. You are at your time if you'd like to reserve your rebuttal.
Yes, please. Thank you.
Okay. Mr. Sonner?
Morning, Your Honors. May it please the court. As we've all been at this long enough to know that probable cause is a fluid and kind of a nebulous concept that's not easy for even a trained attorney or a lawyer or judge to understand and define and apply. But in this case, I do take exception with Ms. Nelson's characterization that the trial court found that the warrant in this case fell well below the standard of probable cause. There was a fair debate about whether the affidavit was sufficient. That was argued by both sides.
But the court found that there was no probable cause and was pretty exasperated by
Yeah,
it.
there's no doubt about that, and I'm not contesting that, Your Honor. But when there's a fair debate about whether there's probable cause, whether
But I guess that's the question: is there a fair debate about it? Because I mean, if you take the Butler County information, I mean, clearly not only is that stale, but it's not even the same location.
No, it's not. I agree with that, Your Honor. And I think what we have here, though, is the evidence that was obtained, or the contraband that was obtained from the trash pull was consistent with what happened at the other residence.
Well, but let me ask you this, just to make sure I understand the state's position. Like, if the state comes to my house and pulls from my trash can the exact same thing that they pulled from the defendant's trash can, and that standing alone, would that be sufficient to justify a search warrant?
Well, I mean, here, no. And I think what the difference is here that we have the same people. It's not the same residence, but it's the same occupants who are occupying the residence in Coleraine Township. There's indication that there's been a pattern of drug trafficking at the prior residence. And
so this is in my follow-up question. Your point about the trafficking, I think, is important. And so my question is, there is zero evidence, unless I missed something, that there was any evidence of trafficking at the new residence in Hamilton County.
That's correct, Your Honor, and that's undisputed in the record. I think my point would be that it's the same occupants that were engaged in this activity in Butler County, and that it was at least a reasonable inference based on the trash pull that these same occupants were engaged in the same activity they had been at the other residence. I don't think there's anything special about the residence in Butler County that would indicate that it would, especially facilitate drug trafficking, or nothing unusual about the residence itself that would indicate that there would be a distinction between the two residences.
Mr. Sauter.
Were these residents convicted in Butler County of trafficking?
Yes, Your Honor.
Is that in the affidavit?
I have the affidavit here, Judge, off the top of my head. I don't remember.
And I guess my point is that's new information that wouldn't have been available. Well, maybe this is I'll save my question for Ms. Nelson, actually, but I am curious if in the affidavit was that they had been convicted in the past, really anywhere, I suppose, of trafficking.
Right. It would take me a while.
That's all right. I just don't remember.
Off the top of my head, I don't remember. And I'm not even positive that it was trafficking there was a conviction for in Butler County, but there were drug charges for which both defendants were convicted. So the trash pull was strongly corroborative that the same activity that had happened in Butler County was happening in Coleraine Township as well.
Sorry, Mr. Satter. My concern is, like, if you look at the paragraphs related to Butler County, they are incredibly detailed and the investigation appears very thorough. And you contrast that with what occurred in Hamilton County, which is whatever the investigation was, it failed to substantiate any, there's no controlled buys, there's no surveillance that indicates there were transactions occurring, there's no CI, there's no nothing. And I guess from a good faith perspective, it seems like we want to encourage the type of investigation that occurred in Butler County and discourage the lack of investigation that occurred in Hamilton County.
Well, Your Honor, the way I would respond to that is there was corroborative evidence. I don't think it's accurate to say that there was nothing in the trash pull that would indicate the presence of drug activity at the residence. There was this what appeared to be residue from cocaine. There is a strong odor of the smell of marijuana, and there are large vacuum bags that are consistent with the way that the defendants had packaged the contraband in Butler County. So I think that there's and I understand that there wasn't the kind of thoroughness that you just described, but to characterize it as there being nothing that would be corroborative of drug activity, I think is contrary to what the record would indicate.
Well,
Ms. Nelson,
I'm sorry, go ahead, Judge Hendon.
Ms. Nelson makes mention of the fact that the information that's contained in most of the affidavit related to a completely different address, and we know that because it's up in Butler County. Right. I'm going to assume that the issuing magistrate realized that this was a different address that he or she was being asked to approve. But can you maybe comment on how that plays into the whole issue of good faith? Because I think we can all agree that the single trash pull, especially this kind of an outside type of trash pull, would not have been enough. So without that Butler County information, this warrant may or may not have been issued. So how do we square the fact that all of the information is coming from a totally different address?
Well, Your Honor, I tried to address that earlier, and I guess I didn't do a very good job of it. I think the important thing is it's the same identity of the occupants are the same in the Colerain Avenue address as it was in the Butler County address. And the Detective Mayer, there is some indication in the record about what the discussion was between Detective Mayer and the municipal court judge. Indicated that what Detective Mayer wanted to do was to emphasize that, hey, look, the first 32 paragraphs of this affidavit are based on things that happened in Butler County, so that there was a clarity there. There was questioning during the motion to suppress hearing about whether there had been some sort of misleading or some kind of chicanery on the part of the detective. And I think that was completely rebutted, and the issuing judge was well aware that there were two parts to the investigation: the Butler County part, which had happened, at least 18 months before, and the things that were found in the trash pull. And I think when we look at the Jones case, talking about the sufficiency of a trash pull, as with most things dealing with probable cause, it's a totality of the circumstances case. And I think what we have to focus on here is whether the affidavit itself was so lacking in indicia of probable cause that no officer could reasonably rely on it. I think when we put the two pieces together here with a prior investigation and the evidence
but I guess here's my pushback on that. You've essentially conceded that both parts, the Butler County and the trash pull, standing alone, are ineffective to establish probable cause. So why does putting two things that are ineffective together suddenly establish probable cause?
I really haven't conceded that, but I would say the reason that would be the case, putting the two together would make probable cause, is that we have to look at the totality of the circumstances, and the totality would include both of those instances of investigation.
What do we do with the fact that the officer waited, I think, five or 6 days from the date of the warrant to execute on it?
Well, Your Honor, there was argument about that at the motion to suppress as well, under the superintendent's rule. There's provided for 3 days, but the weekends did not count. So they did it on a day. First of all, it was not a weekend, and they had to wait for the trash pull until it was a trash day, so that they didn't have to enter onto the curtilage of the if that's your question.
No, my question is, they got the warrant.
Okay.
And then waited 5 or 6 days from the date they got the warrant to execute on it.
I don't think there was any testimony about why that happened or whether there was any prejudice about that, Your Honor. I can't address.
Well, right, but getting back to the point that drugs are ephemeral and can be disposed of quite readily, if you believe that the drugs are at the location, wouldn't you try to act on that warrant as soon as it was issued?
I would, Your Honor, but I can't speak for why the police in this case did not, and it doesn't appear in the record. I can't really speculate about that. I apologize. Just to summarize, I think the trial court said this best in its decision, finding, first of all, there was no probable cause, but also that there was no bad faith. Detective Mayer took the evidence that he had. He put it before the judge, and it was up to the judge to, based on his training and his experience and his official capacity, to determine whether there was probable cause. As the trial court said in this case, the officer's reliance on the legitimacy of the issuance of the search warrant was objectively reasonable. The officer was not in a position to second guess the determination of the judge. And I think in this case, we can't say that the affidavit was so lacking, was so deficient, that no reasonable officer could rely on it. And I would ask the court to affirm the trial court's judgment.
Thank you, Mr. Souter. Ms. Nelson, you have a rebuttal?
Ms. Nelson, can I interrupt with Judge Bergeron's permission? And because I do have this question on my mind, and I'm going back to the good faith of the officer. And I think we all agree that the officer doesn't have to be a lawyer or a judge or look at the intricacies of the law. And in this case, forget the stale evidence. What if all we had was a single trash pull and knowledge by the officer that the defendants had been convicted of trafficking in the past? Would that be enough under the Supreme Court trash pull case? It says a trash pull alone isn't enough, but it might be if there was background information that showed drug activity. I mean, would the officer still be acting in bad faith?
Under the circumstances of this case, good faith would still not apply. The case you're referring to, I'm assuming, is State v. Jones, the trash pull case.
Yes.
You consider the totality of the circumstances.
Yes.
So I think the distinguishing fact between that case and this case was that the background information was specifically related to the target residence. So yes, we had trash pull.
Can't it also be to the specific people? I mean, if you've got if you've got somebody that's been convicted, let's say somebody's been convicted of 10 felony drug trafficking offenses, and the police do a trash pull, and there's evidence that it could be evidence of trafficking, the bags, the residue. Are you saying that an officer who got a warrant in that case would not be acting in good faith? Even if it's the drug dealers move from one residence to another.
So just to clarify, the residue and the drugs that were found in the trash, separate from the vacuum sealed bags, right, was only indicative of personal use. So when we're talking about good faith and probable cause to support a search of the residence for trafficking, no, the answer in this case is still no, because there was no other information in the investigation related to the target residents and the defendants continuing to engage in trafficking-like behavior in Hamilton County. So while prior convictions may inform an investigation, there was still a substantial lack of investigation in this case. And it kind of points back to Judge Bergeron's point. In this case, we would have liked to have seen something more substantial, not even at the caliber of what happened in Butler County, but something more that connects drug trafficking to the target residence, because that is what the officer is asking a search warrant for, because he has a fair probability, evidence of a fair probability that evidence of contraband would be located in the residence. And that's not in any way what we have here, compared to Jones, where they had substantially more information related to the target residence, that substantial background related to the target residence that we don't have in this case. So when we're talking about the lack of good faith in applying the exclusionary rule, we would promote deterring this type of lack of investigation in the future, and which is why this case absolutely calls for reversal and that the evidence should be suppressed.
Thank you, Ms. Nelson. Thank you both for your arguments this morning. We appreciate them. Very, very challenging case. We'll take the matter under submission and issue a timely written decision.
Thank you, Your Honors.
All right, have a great day.
Yes.